Divorce proceedings may be difficult and consider several factors, but child custody and visitation orders boil down to one thing: the best interests of a child must guide each determination. The 1992 case of Hanke versus Hanke demonstrates the bounds of a court's discretion when there's evidence of child sexual abuse. In 1986, Dan Hanke sexually abused his 11-year-old stepchild. The stepchild told her mother, Mary Hanke. Mary and Dan separated, and Mary brought criminal charges of sexual molestation against Dan. Dan admitted to sexually abusing his stepchild and said that he was drunk when it occurred, but claimed he didn't have an alcohol problem. Several incidents of, quote, excessive punishment with sexual overtones, unquote, had occurred leading up to this. Mary and Dan divorced 4 years later. Mary was pregnant when they separated and was granted custody of this child in the divorce. When their home was sold in the divorce, Mary and her children moved from Maryland to Pennsylvania. Almost a year later, Dan was granted 4-hour unsupervised visitations on alternate Sunday afternoons, but was ordered to undergo a mental health exam. Dr. Lawrence Raifman evaluated Dan and testified on both Dan's alcohol abuse and abuse of his stepchild. Dan physically abused his stepchild for a long time before sexually abusing her, which Dan said he did to, quote, get at her mother, unquote. Dr. Raifman concluded that Dan abused alcohol, but hadn't come to terms with it, and that Dan had a specific type of child physical and sexual abuse disorder. Dr. Raifman noted that Dan shouldn't be alone with his child or stepchild, and that Dan needed therapy. 2.5 months later, the 4-year-old child told her mom that she was inappropriately touched by her father during a visitation. Mary filed a report of sexual abuse. The local Department of Social Service filed a petition recommending that Dan's visits be supervised and that Dan shouldn't be alone with the child at any time. A couple months later, Mary moved with her children to Kentucky to be with her family. The attorneys for Mary, the child, and the local Department of Social Service all called for supervised visitation. When the petition and visitation matter were eventually heard by a judge, Dan was granted overnight visitation with the child, with one of 4 specified people close to Dan present during the visitations. The judge seemingly favored a small showing of contradictory evidence that alleged Mary was overreacting and Dan wasn't a danger to their child. 5 months later, the court that had decided the terms of visitation changed the child's custody from Mary to the local Department of Social Service. Then the court transferred custody to Dan and terminated the child support Mary was receiving. However, because the child resided in Kentucky with Mary, the child was placed in the custody of Kentucky's Department of Social Services while the department investigated Dan. Mary Hanke appealed the order, granting Dan Hanke overnight visitation with their 4-year-old daughter.